is a different kind of storm that is brewing right now. A federal judge is now demanding that the Justice Department explain President Obama's comments on the health care law and the Supreme Court that he made yesterday at an AP luncheon. The judge says that the DOJ has roughly 24 hours to clarify whether President Obama believes that judges have the power to overturn federal laws. A Justice Department attorney facing the Fifth Circuit started to answer that question. Watch this.
Yes, Your Honor. Of course, there would need to be a severability analysis, but yes.
I'm referring to statements by the President in the past few days to the effect, and I'm sure you've heard about them, that it is somehow inappropriate for what he termed unelected judges to strike acts of Congress that have enjoyed, and he was referring, of course, to Obamacare, to what he termed a broad consensus and majorities in both houses of Congress. That has troubled a number of people who have read it as somehow a challenge to the federal courts or to their authority or to the appropriateness of the concept of judicial review, and that's not a small matter.
It is not a small matter, according to that Fifth Circuit judge, Judge Jerry Smith. And I'm joined now by Michael Mukasey, who is the former U.S. Attorney General. Judge, welcome. Good to have you here today.
Good to be here.
This is interesting on a number of levels. This was a separate healthcare. This is a separate healthcare question that was being determined in the Fifth Court. But I'm curious what you think about the fact that in the middle of that proceeding, which had its own specific kind of directive and reason for being, the judge sort of segued and brought up something that the president had said at an AP luncheon yesterday and asked this representative of the Department of Justice to defend it.
Well, I don't think it's all that surprising because they're arguing the healthcare provision different from the one that's in front of the Supreme Court, but they are arguing a healthcare provision in the Fifth Circuit, and the president has authority over every department of government, including the Justice Department. He has authority to direct the Justice Department as to what positions to take. He is also, as it happens, a lawyer. And he's not just a lawyer who had a storefront someplace where he drew wills and did house closings. He professes to be a professor of constitutional law. And such a person having that authority to say that the courts owe deference to elected officials and that it's somehow improper and overreaching for a court to strike down a statute is wrong as a matter of history. That's why the founders put the Supreme Court there. That's right in the Federalist Papers when they were convincing people to adopt the Constitution. Since Marbury versus Madison, it's been true. That was back in 1803, and courts have been doing it merrily ever since. Yeah. But when the president calls that into question, the court has, it seems to me, every obligation to sit up and take notice.
The president made some original comments on all this 2 days ago that got a lot of attention. Then yesterday, it felt like he was sort of kind of reestablishing his bona fides as a constitutional professor in the way that he tried to talk about this issue. And I know we have two sound bites in the control room right now, but I'd like to hear from President Obama and what he said specifically yesterday and get Judge Mukasey's thoughts on that. Let's hear from President Obama again.
And so the burden is on those who would overturn a law like this. I expect the Supreme Court actually to recognize that and to abide by well-established precedents out there.
His argument seems to be that because, in his opinion, it's so compelling to give everyone health care that the court should, override everything else and see the need for it and rule in the favor of upholding this law.
The court isn't there to decide policy. That's the president's job. The court is there to decide whether, in this, what the president says is a very important issue, the president has chosen a constitutional means for doing that. If the answer to that is yes, the law gets upheld. If the answer is no, it doesn't, and it doesn't matter how important it is in his eyes or anybody else's.
Interesting. So I want to go back to this Fifth Circuit Court of Appeals and what happened in there yesterday. The judge basically, he looked at the lawyer and said from the Justice Department, you have 24 hours, and here's your homework assignment.
Actually, he gave them 48 because it was yesterday, and they can submit it
48
tomorrow.
hours, so there's an extension on the homework assignment. 3 pages. double-spaced, single-spaced,
Single-spaced.
excuse me, 3 pages single-spaced. I guess I got some of those assignments wrong myself. Is that unusual for a judge to say, here's your homework assignment to the DOJ attorney, and you better be back here in 48 hours with a 3-page paper on it to back up what you're saying?
Actually, it's not. Courts ask lawyers to back up their positions with briefs all the time. What's unusual to me is that courts usually set page limits. They say, don't submit more than 2 pages or 3 pages.
So this is the minimum.
What they were saying is, we don't want some smart alecky offhand response. We want 3 single-spaced pages with a serious discussion. That is unprecedented. I've never seen a court set up. Hey, they asked for it. I think they'll get it. Whether that's the end of the story or not is a different story. But they asked for 3 pages. They'll give them 3 pages.
Very, very interesting. Always great to get your insights on these stories. Judge Mukasey, thank you so much for being here. Good to see you.
Thanks a lot.
We'll see you soon.